Right, greetings. Yes. Thank you for this opportunity to meet with you this morning. I don't know what time I'm meeting you, but on my side it's the morning. And it's the morning of the 22nd of October, that is 2025. I am discussing today a very interesting subject, and I've decided to tackle my discussion. All ZANU PF lawyers must go back to law school. Why am I saying that? This past weekend, ZANU PF met in Mudare as an organization, and in terms of their own internal processes, which have nothing, absolutely nothing to do with the rest of us. They decided that they were going to extend the term of office for this presidency as well as this current parliament of Zimbabwe by a further 2 years. You will remember that in 2023, in August, some general elections were held in Zimbabwe, in terms of which the executive, that's the presidency and his deputies, and the parliament of Zimbabwe, as well as the local councils or local authorities, this harmonized election, so it actually elected the president and all the lawmakers at different tiers of government. So basically, the term, according to the constitution, is a 5-year term, which then literally ran from 2023 in August, September, thereabout, and it's going to end in 2028 according to the constitution. But when they met, they resolved to extend the term by a further 2 years. And that is the subject of my discussion today. Hence I'm saying the people that are advising ZANU PF legally, they must all go back to law school, because they seem to have misread the law in many aspects. And I'm going to explain why I say so. Let me again bring up this disclaimer that the ZANU PF internal processes really have nothing to do with the rest of the people of Zimbabwe, in the sense that membership to ZANU PF is optional. Anybody who decides to join is free to join, and they have got their own rules, their own laws, their own procedures, ways of succeeding one another, electing one another to positions of office and influence and so on. So that is entirely their own internal processes. Then that's very perfect in a democratic country like Zimbabwe. But then it becomes a problem when a party which happens to be the ruling party with a 2/3 majority in parliament, well obtained in many ways, not through an election, of course. We know what Sengezo Shabangu did and all those recalls, but that's not a subject for today. Today the issue is about whether ZANU PF as a political party have a mandate to extend the parliament's term, that is the current running parliament, by a further 2 years. And if they can do so, the question is, what legal or constitutional basis would they have for doing so? And I argue in this presentation that there is no legal basis for the extension of the term of parliament and the term of presidency by a further 2 years. So even if they were to go ahead and amend the constitution, I am going to demonstrate here that they still will not be able, because legally speaking, their term of office is a fixed 5 years, and it's going to literally end on the sometime in August or September 2028, we will look at the formula for determining that period in a moment. Now, the document I have here is the Constitution of Zimbabwe. If you have not read it, I encourage you to download it. It's there on the internet. But most importantly, you can visit government printers and look for it and buy it. It's quite affordable. Because you see, you need information in order to be a good citizen. And if I could just highlight that in terms of the Constitution itself, particularly, let me look at this provision. There's a provision here which says that that is Section 7 of the Constitution of Zimbabwe Amendment 20 of 2013. Section 7 says promotion of public awareness of the Constitution, and it reads as follows: the state must promote public awareness of this Constitution, in particular by translating it into all officially recognized languages and disseminating it as widely as possible. If you have not seen the Constitution or a copy of it in your language, whether it is I don't know what your language is. There are so many languages that are spoken in Zimbabwe. We have Chewa, we have Chibaro, we have English, we have Kalanga, we have Khoisan, we have Nambia, we have Ndau, we have Ndebele, we have Shangani, we have Shona, we have Soto, we have Tonga, we have Tswana, we have Venda, we have Xhosa. So if you have not seen the Constitution circulating in your own language, then maybe that might just be an indication that there's been an omission, because the state must promote public awareness of this Constitution, because it has to translate it, and it has to require this Constitution to be taught in schools as part of the curricula for the training, as well as for training of members of the security services. So your police, your army, your prison services, they must all have been taught, as well as the civil service and members employed by public institutions. So basically, when you walk into a public office in Zimbabwe, you expect that the person who is in that office knows the Constitution, because it must be taught to them according to itself. And then the state must promote public awareness by encouraging all persons and organizations, including civic organizations, to disseminate awareness and knowledge of this Constitution throughout society. So again, the state is obligated to ensure that everybody knows the Constitution. That's according to Section 7. But remember, that's not what we are talking about today. But just talking about Chapter 1 of the Constitution, the founding principles, it says Zimbabwe is a unitary, democratic and sovereign republic. Okay? And then Section 2 says the supremacy of the Constitution. It says, this Constitution is the supreme law of Zimbabwe, and any law, practice, custom, or conduct inconsistent with it is invalid to the extent of its inconsistency. I want you to take note of Section 2, subsection 1, because it says here, this is the supreme law of the land. So any act or conduct or practice must conform to it. If anyone purports to do anything which contradicts what is in the Constitution, clearly that is in violation. And then subsection 2 says the obligations imposed by this Constitution are binding on every person, natural or juristic, including the state and all its executive, legislative and judicial institutions and agencies of government at every level, and must be fulfilled by them. So this Constitution binds everybody, including ZANU PF, including the President of Zimbabwe, whoever it happens to be at a particular time, including every member of parliament, whatever his or her name happens to be from time to time. Now, Section 3 is what I want you to pay attention to, particularly Section 3, subsection 2. But Section 3 is about the founding values and principles. And it says Zimbabwe is founded on respect of the following values and principles. Supremacy of the Constitution is one of them, clearly stated. Then the rule of law. I want you to take note of the subsection, Section 3.1b on the rule of law, because in our discussion we dwell very much on the rule of law. What does the rule of law say And can ZANU PF fast track their constitutional amendments to extend the term of the parliament and the presidency by a further 2 years? And would that be consistent with the principle of the rule of law as it is enshrined here in section 3(1)(b)? And then I want us to skip to section 3, subsection 2, which says, the principles of good governance which bind the state and all institutions and agencies of government at every level include the following. So these are the principles of governance. And again, we are told that they bind the state and all institutions and agencies of government at every level. Remember, the president and the presidency as an office is an institution of government. And the Parliament of Zimbabwe is an institution of governance. So they are bound by the following: a multi-party democratic political system. So whenever people form political parties and run political parties, it is not at the indulgence of the ruling party. It is a right that is enshrined in this constitution. Everyone has a right to form a party and support a party and promote a party and so on, just like the people in ZANU PF. It is their constitutional right to do so. And then we are saying section 3(2)(b) says there is an electoral system based on universal suffrage and equality of votes. So it's universal suffrage. Men and women above the age of 18 who happen to be citizens of Zimbabwe are eligible to vote. Not only to vote, but to also raise their hands and become candidates. My excuse about that. Then, excuse me. The other element, as part of an electoral system based on universal suffrage and equality of votes, we talk also about free, fair, and regular elections. I want you to take note of the word regular. Underline it. Regular means that the intervals are predetermined. So in our case, it's every 5 years. As for the determination of the end of the 5-year period, I am going to share with you as we get to section 143. But at the moment, I want you to underline that, underscore the fact that it is regular elections. And then we are saying, well, there will be issue of adequate representation of the electorate. It doesn't concern us at the moment. I want you to look at section 3(2)(f). F says, the principles of governance which bind the state and all institutions and agencies of government at every level include respect for the people of Zimbabwe, from whom the authority to govern is derived. Now, this is very important. I want you to underline section 3, subsection 2(f), because it says the authority to govern is derived from the people. That's very, very important to take note of, because it is this a basis of authority that I want us to zero in. It says the authority to govern is derived from the people of Zimbabwe. Now, whilst you are looking at that part, we said, let me just summarize again what we said regarding section 3. It says, section 3(1)(b) says the principles that are sound and fundamental. One is the rule of law. And section 3(2)(f) says respect for the people of Zimbabwe, from whom the authority to govern is derived. And read together with section 3(2)(a) and Roman number 2, free, fair, and regular elections, because that then forms the basis of my argument. Right. Again, let me put it this way. The main thrust of my reasoning and argument is that ZANU PF, even if they were to go ahead and amend the constitution, barring that they have all whatever is needed to amend the constitution numerically in terms of the thresholds in parliament and so on, Suppose they sail through the process. That's not where I am. At the moment, I am looking at the authority to govern, because that is what will determine whether their rule beyond 2028 will be legal or it will be an act of treason. You see, I wrote an article and shared it, and one of my friends, when he read, after reading that part where I said that this resolution is an act of treason, or rather it proposes treason, my friend said, that is too strong a language, why do you use that? But let me explain why I believe it would be an act of treason to do so. It says the executive authority, that is section 88 of the Constitution. It says the executive authority derives from the people of Zimbabwe and must be exercised in accordance with this Constitution. Now, this takes us back to section 3, subsection 2F, where we were told that the authority to govern is derived from the people. It is reiterated in section 88(1). The executive authority derives from the people. So it is the people that confer executive authority to the president. It is not inherent in him in an individual capacity by virtue of any special virtues, forgive my pun, but rather the power to exercise executive authority is derived from the people of Zimbabwe, which basically means any exercise of power that is not derived from the people has been usurped from the people, it has been taken from the people by force without their consent, and that it becomes a basis for illegitimacy. Because the executive authority of Zimbabwe vests in the president, who exercises it subject to this constitution through the cabinet. So the president receives the executive authority which is conferred by the people, and then he exercises it subject to the constitution. Now take note, the power of the authority is not derived from, it's not conferred by the constitution. It is conferred by the people, and it is exercised subject to the constitution. You know, the kind of logic that I've been hearing being thrown around is that as soon as the ZANU PF are able to amend the constitution, amend all the provisions that they want to amend, then automatically the president and the parliament will be empowered to go beyond 2028 to 2030. That's precisely the reason why I say ZANU PF lawyers must really go back to law school, because they have misread the law here. It says the authority to govern is derived from the people. It's not conferred by the constitution. It is conferred by the people. So imagine this. In 2023, people elected the president and the parliament. Now, let's suppose that by some imagination somehow, they go in there and they all connive, the presidency and the members of parliament, all of them. They connive that they are going to now change the constitution and confer upon themselves a term of office for the next 30 years or the next 50 years, whatever they might decide to do. If the power is conferred by the constitution, it would literally mean that as soon as they have amended the constitution, they can then confer upon themselves a power and an authority to govern beyond, rather in an unlimited manner. That on its own is an act of treason, if you look at it very carefully. Because remember, when they were sent in 2023, they were sent with specific reference on a specific term which ends at a specific time. So if literally they are going to change the constitution, it would not by any stretch of logic and imagination imply that they can extend themselves and rule ad infinitum without then having to come back to the people to seek a further mandate. Their mandate ends precisely at the exfluxion of the 5-year period. It cannot be extended except by the mandate of the people. That's what Section 88 here implies. But let's look again at Section 117, because this Section 88 was speaking in respect of the presidency, the executive. Let's look at the authority of the legislature, that is the members of parliament, whether it's national parliament or council level representative or councillors. It's basically the same. Section 117 says nature and extent of legislative authority. It says the legislative authority of Zimbabwe is derived from the people and is vested and exercised in accordance with the constitution by the legislature. Again, it is derived from the people. If it is a council level, it is the councillors, but the councillors have been sent into that council by the people. So at every 5-year period, as a measure of review, they must go back to the people who will say you have executed your 5 years well, or you have not executed your 5 years well. We are taking you back to parliament, or we are calling you back, we are sending somebody in because you failed us, and so on. So that applies whether it's at council level or it's at the National Assembly level, the House of Assembly or the Senate. So it says it's derived from the people. Now we saw this statement first and foremost in Section 3, Section 3(2)(f). It says this authority is derived from the people. We saw it again in Section 88. It says it is vested in exercise in accordance with the Constitution, right? And we saw in Section 2, excuse me, that the Constitution is the supreme law of the land. Now we are told here that the legislature or the legislative authority confers on the legislative power the power to amend this Constitution in accordance with Section 328. Another contentious provision. If we do get time, we will get to it. And then, so the legislature may amend this Constitution based on the provisions in Section 328. That is the basis that ZANU PF are using to say they are going to amend the Constitution, and then they are going to have the president running beyond 2028 into 2030. But remember one thing, the presidency's term runs concurrently with the parliament's term. So there's no way you can extend the presidency without extending the parliament, unless you will be disrupting this harmonized nature of our elections. Remember the Constitution before 2013, after its alteration, you see, from the Lancaster House original provisions, we got to a point where there was a disharmonization between the executive term and the parliament, a parliamentary term. As you remember, in 1995 we voted for the parliament, and then in 1996 we voted for the presidency. Then 2000 we voted for the parliament, and in 2002 we voted for the presidency. Then 2005 parliament, 2008 the presidency. So that was that kind of a disharmonized election. But the 2013 consolidated and harmonized these terms again, so that they would run concurrently, because that issue of this lack of harmony in itself was actually causing a lot of administrative problems and so on. So Section 3(2)(f), Section 88 and Section 117 tell us very clearly that the power to govern is conferred by the people, because it is derived from the people. It's not derived from the Constitution document, but it is derived from the people. That's very important to take note of. So that then brings us to the issue of the debate and the plans and the resolution of ZANU PF, as one might want to be looking at it. You see, what you find here is that ZANU PF's resolution in itself and in essence, is a plan to commit treason. Now, I'll explain. Don't get too agitated. Why? Because it is a plan to extend the term of office beyond the constitutional limit. There is a constitutional limit which was imposed by the Constitution, and it runs up to 2028. So, we have looked at the various provisions that confirm that power is derived not from the Constitution, but from the people. So why is it so important? It's because I want to underscore the fact that if any member of parliament continues to exercise legislative authority beyond the expiry of the 5-year period in 2028, that person will be acting outside the mandate that was conferred by the people. Was the people conferred a limited mandate of 5 years, running practically from the day of the inauguration of the president in 2023, from that date when the president was inaugurated, right through up to the expiry of the 5 years. That term of office will come to an end. That's a fixed term. It's not negotiable. And the parliament cannot then amend the law to confer itself an extra period. As I have underscored, and I mince not my words, that would be an act of treason. And anybody who is seeking to participate in that treason must understand that this treasonable act is prosecutable in essence. The same applies to a president who was elected on the basis of a 5-year term. Should he continue beyond the 5-year period, then the question is, what would be the basis of his or her mandate to continue thereafter? And this matter has got to be made clear even to the judiciary itself. Remember, members of the judiciary are sworn in to protect the Constitution. So the president is sworn in to protect the Constitution. The legislature and all those members are sworn in to protect the Constitution. And so is the judiciary, the Chief Justice and all the judges of the Supreme Court, the High Court, the magistrates, everybody who is within that legal, that judicial system. So they are all sworn in to protect the Constitution, not to subvert it. What is to subvert a constitution? It could mean conniving as members of government and then altering things here and there in violation of the separation of powers. Because we know that Zimbabwe runs on the principle of a separation of powers, and on that basis of the separation of powers, I think one error that I've seen mostly is people always talk in terms of the power, separation of powers between the executive, the legislature, and the judiciary, as if those are the 3 pillars. But they forget this last one, and this is the one that I want to bring up in this lecture. It is the electorate. They are part of this. So the separation of powers doctrine, what they call trias politica, it's not only trias, it's not only 3. It has a 4th leg. And that 4th leg is the people. That is what according to section 8.8 and 117 as well as section 3.2f, they are the source of all government authority, executive, legislative. That's what we learned. So what we've been hearing then is as a way of overshadowing the extension of the term of parliament. We've been hearing more talk on the extension of the term of the presidency. But as I will illustrate in a moment, you can't extend the term of the president without extending the term of the parliament, because constitutionally they are meant to run concurrently. Somebody says they might have to, if ZANU PF they have to amend the law and remain legal, they will have to amend the whole constitution, and that would mean then amount to rewriting the constitution rather than amending it. But anyway, let's look at Section 91, or Section 89 says the president is the head of state and government and commander-in-chief. Then the duties of the president are stated in Section 90. I want us to look at Section 91, which says the qualification for election as a president and a vice president. It says a person qualifies for election as a president or vice president if he or she is a Zimbabwean citizen by birth or descent. You know, the criteria is listed for us there. I want us to look at subsection 2, which says a person is disqualified for election as a president or vice president if he or she has already held office as president under this constitution for 2 terms, whether continuous or not, and for the purpose of this subsection, 3 or more years service is deemed to be a full term. Now, let's look at this subsection 91, subsection 2. That is the major preoccupation and obsession of ZANU PF. They believe, and they have argued, and they've said it many times, that Mr. Mnangagwa is a very good president. They would want him to continue into another term of office. In fact, they don't want him to continue into another term of office. They want to extend the current term of office by 2 years. Where I think they are mixing things. Hence, I'm imploring ZANU PF lawyers to go back to school, particularly on this basis of Section 91, subsection 2. If they would want Mr. Mnangagwa, who they say is a good president, to continue in office, and that is their democratic right to do so. But what must they do? They must, if they go ahead, for instance, and amend Section 912 so that instead of limiting his term to 2 terms, they could then, they could then amend the constitution so that he can be allowed to stand for a 3rd and a 4th term, whatever number they want him to stand. That on its own would not be constitutionally problematic if they are able to achieve that. It says a person is disqualified for election. So Mr. Mnangagwa stands disqualified after 2028 because he completed Mr. Mugabe's term, that was in 2017 November up to August 2018 when the election was held. And then, so part of Mr. Mugabe's incomplete term, uncompleted term, and then 2018 to 2023, that was 1 term. 2023 to 2028 is a 2nd term. And now in terms of Section 912, he stands disqualified. So they want him to continue. But where they get it all mixed up, and I wonder how they are reading it, is to assume that the moment they have amended Section 912, it then automatically confers 2 extra years to the president and to the parliament. I mean, there's just no way that could be achieved by merely, lifting this disqualification. If an amendment lifted this disqualification of Mr. Mnangagwa, it does not then mean that his current term is extended by a further 2 years. It simply implies that in 2028, he can stand again and be a candidate. That's what they should be talking about. Not this idea of assuming that once this disqualification is lifted, then it automatically confers upon him an extra 2 years. Because as we have already belabored the argument, the 2 years that he is asking for will not be conferred by the Constitution, because it is not the Constitution that confers the right or the power to govern. The power to govern is derived from the people. So even after getting this qualification lifted, Mr. Mnangagwa will still have to go back to the people and ask them to give him an extra a period, another term. In fact, he'll be asking for another term. That is precisely what they should be arguing. So on the basis of section 91 subsection 2, even if, as I have said, they managed to amend this one, it does not then automatically confer an extra 2 years, because the 2 years do not come from the Constitution, they come from the people. Now, another interesting section that has been mentioned in this whole debate and this whole hullabaloo is the election of presidents and vice presidents according to section 92. It says, the election of a president and 2 vice presidents must take place within the period specified in section 158. So the period is specified in section 158. We will get to that. So the period specified in section 158 is the one which determines for how long a president can remain in office after an election. That's the duration of the duration of the parliament, is the duration of the presidency. It is regulated by section 158. So somebody might assume they will go and amend section 158. So now they'll have to amend section 2, section 3 on the rule of law. They will have to amend section 3.2 on the source of governance authority, which is the people. Then they will have to amend section 88. Then they will have to amend section 117. Then they will have to amend section 912. Then they will have to amend section 158. Eventually they will have to amend section 143, and they will have to amend section 328. So those are the precise legal provisions that ZANU PF will have to amend. So it's not going to be one amendment. It's going to be several fast-tracked amendments. And they will not even amount to an amendment, but a mutilation of the Constitution, if one could call it that. So it says here, election of a president and 2 vice presidents must take place within the period specified in section 158. So the period is specified in the Constitution. The subsection 5 says, the election of a president and vice presidents must take place concurrently. I want you to underline that part. Concurrently with every general election of members of parliament, provincial councils and local councils. So, provincial council elections, local council elections, members of parliament, and the presidency, the election must run concurrently. Hence, I say it's not just about the extension of the term of office of the president. It should not, you talk about the president should not cloud everything to do with the local councils, with provincial councils, with the National Assembly and Senate. It's everybody being given an extra 2 years. That's why I'm saying the people that were elected in 2023 will then have to meet in the respective legislative assemblies and then extend their own mandate. Not by going back to the people this time, but by sitting there in those parliamentary chambers and legitimizing themselves, legalizing themselves in a term that is not conferred by the people of Zimbabwe. Hence, I call it a coup, I call it a haste, I call it treason. Those are the precise words, and there's no mincing our words here. That's precisely what it is. You may call it anything else by way of euphemism and being conservative in your use of language, but in legal parlance, that's what it means. It's treason. What is treason? Treason is an unlawful and intentional act of, overthrowing an established authority. Right? And you say, who is the established authority? The established authority is the people of Zimbabwe, because they are the ones who vote. They are the ones who confer executive authority. They are the ones who confer legislative authority. So if you are going to do anything that ousts their jurisdiction and their power and their right to confer or withdraw legal, government authority, then you have overstepped their rights, you've actually overreached their rights, you've acted in collusion. So that would be a collusion between the legislature and the executive, colluding to steal the rights of the people who are entitled to regular, I said regular elections, regular free and fair elections every 5 years. We are going to see that in section 143. So let's go then. It says here in section 92(1) says the terms, the period is specified in section 158. And section 5 says the election of the president and vice presidents must take place concurrently with every general election. We have seen that. So it's going to be the president's term extended by 2 years, parliament's term extended by 2 years, provincial council and local council terms extended by 2 years. And the question is, what would be the basis for that extension, if not a subversion of the right of the people, if not an infringement of the separation of powers? Because it is the power of the people to confer or withdraw a mandate. So any extension of a mandate which does not go back to the people, it amounts to a theft or a haste. It is a stolen mandate. Now, we've spoken about, in fact, when we read section 92, it's subsection 1 said that the power to govern is actually, in fact, it says the term limits are determined, the periods are determined by section 158. But before we can, maybe let's just read 158, then we'll go to 143. Section 158 says, the timing of elections, a general election must be held so that polling takes place. Listen to this. So polling takes place not more than 30 days before the expiry of the 5-year period specified in section 143. So the 5-year period is specified in section 143, which means not more than 30 days before the election must be held. And where Parliament has passed resolutions to dissolve, well, we are not talking here in terms of, you know, there are times when Parliament may be dissolved on several grounds. Voluntarily, the Parliament may ask the President to dissolve it after its own resolution, or it may be dissolved on the best, following a vote of no confidence and so on. So we are just going to concern ourselves with 158(1)(a). And then 158(2) says general elections to local authorities must take place concurrently. Again, the issue of concurrency is underscored and repeated here. So they must take place concurrently with the presidential and parliamentary elections. So section 143 determines the 5-year period, and the issue of concurrency is as underscored again in 158 subsection 2. Now let's go to section 143. And I want us to read subsection 1. 143(1) says, well, 143 actually is on the duration and dissolution of Parliament. So 143(1) says, Parliament is elected for a 5-year period which runs from the date on which the President-elect is sworn in and assumes office in terms of section 94(1)(a). And Parliament stands dissolved at midnight on the day before the following day in the next general election, called in terms of section 144. Right, listen to this. Following the 2023 general elections in August, the President, Mr. Mnangagwa, was sworn in September. I can't remember the exact date, but you can find it. And then, from that date when he was sworn in, we count 5 anniversaries, 5 years. So at the expiry of that 5-year period, Mr. Mnangagwa's term of office legally comes to an end. And because it runs concurrently with the terms of Parliament, Provincial Council and Local Council, it means all those will also legally come to an end. So then, the question is, if they are going to continue beyond that date, what will be the basis for continuing? Who will have conferred the authority by which they will continue beyond the expiry of the 5-year period? If the ZANU PF lawyers may help us to understand this part, I would gladly welcome it. Remember, I'm not talking to politicians. I'm talking to the ZANU PF lawyers. Why am I talking to the ZANU PF lawyers? Because they are the ones who have advised the party that this thing is legally possible. Meanwhile, this thing is not legally possible. As I said, they will then have to amend section 143(1), which says that the power, or rather the term, the 5-year term runs from the date. And it says a 5-year term, by the way. So they want it now to extend it to a 7-year term, because to amend this part would now mean a 7-year term. And remember, it's not going to be a once-off amendment which will affect this current term of office. It would then peg it at 7 years. So it would then mean if the election is, if the constitution is amended, that to allow this term to run up to 2030, it would have extended it by 2 years. So the next election would then not be 2033, but would be 2037. Because from 2030, the 7-year period will take us to 2037. So this whole thing, as you can see, it's threatening to throw Zimbabwe into a constitutional crisis, because it is extending a 5-year term by 2 years, because they will have to amend this 143(1) to make it a 7-year period, to bring it to align Mr. Mnangagwa's term and this choice of this principle of adding 2 more years. So they will have added 2 more years. So it will then mean from 2030 to 2037, and from 2037 the next 7-year period would be 2044. Now, is this what the people of Zimbabwe deserve? Why did the constitution make up for 5 years? It was basically because after 5 years, a president or members of parliament have been given enough time to do whatever they were sent to do. Then it is now up to the people to review that mandate. So they go back to the people and ask for a further mandate. Hence I was saying, if ZANU PF were very sincere and they are as democratic as they claim to be, then they should only then be talking about amending section 92 section 91 subsection 2, and then confer giving Mr. Mnangagwa another opportunity to stand as a president. And then if they have the support of the people, as they always claim to do, they'll go and campaign, the people of Zimbabwe will vote him again in, then he will do the work that they want him to do. Instead of usurping this authority, taking it from without the consent of the people, they should go back to the people. So section 143 is very clear that this is a 5-year term, and the time will begin to count on the date when the president-elect is sworn in. So that was September 2023. And then, so at the expiry, Mr. Mnangagwa will have to, if he still be the incumbent president, whoever will be president at that time, will have to declare the election date in terms of section 158. As you can see, section 144 says, where Parliament has not earlier passed resolutions to dissolve in terms of section 143(2), the President must, by proclamation, call and set dates for general elections to be held within the period prescribed in section 158. So section 144 enjoins the President. In fact, it mandates him to call for an election based on Section 143(2), the President must by proclamation dissolve Parliament if the Senate and the National Assembly sitting separately by the votes of... Well, no, this one doesn't apply. Section 144(1) applies when the Parliament has run smoothly without any interruptions. So at the end of this 5-year term in 2028, the President has no choice, but he must proclaim an election according to the law. As a law-abiding President, he will have to then prescribe a date as determined in Section 158. So, the question then is, what happens if the President, come 2028, does not declare an election date according to, in compliance with Section 143(1), according to Section 144(1), and if refusing to activate the election period according to Section 158? If he does not do so, that would be a treasonous act, because then that would be a subversion of the Constitution. He was sent in there on the basis of a limited 5-year period. So as a servant of the people who have conferred that executive power and authority on him, when the term of office comes to an end, he must declare the election date. It's not that he has a choice whether to do it or not. It is mandatory according to the Constitution, according to Section 144(1). So any failure to do so is something quite problematic in a sense. And the question is, what would be the cure for such a treasonous act? So, this is very simple and very straightforward. At the expiry of the 5-year period, the President, acting on the basis of Section 144 and 158, must declare an election date in 2028 for another term of office of 5 years, or if they would have amended Section 143(1), then 7 years, whatever it might be. You see, so these are the issues that really have occupied the public discourse for some time. There was a mention of Section 328, the one on whether it is legally feasible for ZANU PF to fast track these amendments or not. Let us look at this Section 328 in order to gain at least some understanding on what it says. But before I even do that, let me begin by making a disclaimer. Now, the thrust of my argument really has not been on the viability or the feasibility, rather, of amending the Constitution and so on. If you will have remembered, I have mentioned quite a number of provisions which I said ZANU PF will have to amend in order to even achieve what they are talking about. I said they must amend Section 3, subsection 2, and that would be the paragraph 1b on the rule of law. What is the rule of law? The rule of law, which encompasses such principles as legality and so on, says that it holds that the law is an antecedent normative system, and every conduct must adhere to the laws and the rules and the principles and the dictates and the ordinances that have already been laid down. So, some people have been saying, because the parliament has the numbers, Therefore, whatever they sit down and agree and write down then becomes the law. Now, that kind of reasoning seems to flow from the discredited school of legal thought once espoused by the likes of John Austin, who said that the law is the commands of the sovereign. In other words, the president is sovereign, the parliament has sovereign power, so when they meet and decide to rewrite the constitution, then whatever they say will then carry the day as the new law. Now, if that kind of reason is followed to its logical end, it means that the law is a whim, is a caprice. It would mean that it is unpredictable. It would then mean that people are living in a jungle. Because if the law cannot be known in advance, then surely people are not living according to the law, but they are living according to a whim and a caprice. And that would be a very dangerous place to live in, because it means that whoever is in authority can do whatever he wants and then justify himself after the fact. So then why call that a law? You know, there's a very interesting article that was written by a certain South African scholar, Murainik, I hope I'm getting the Afrikaans name right, but his surname was Murainik. Right at the dawn of South African democracy, he wrote an article entitled "The Bridge to Where," because then he said the South African Constitution was a bridge. That's what it claimed. The interim Constitution, Act 200 of 1993, had actually claimed that the Constitution was a bridge. And so Murainik was asking the question to say it is a bridge to where? Because for it to be a bridge, it must be a bridge between one thing and the other. And one of the most profound statements he made there was one where he said, it is a bridge from a culture of unqualified authority to a culture of accountability. You see, as I have said, if the executive and the parliament are endowed with power to sit down, change the law through connivance and collusion, and then call that a new law that every Zimbabwean must now abide by, then literally speaking, it would mean that Zimbabwe is not run on the basis of a rule of law, but it would mean that it is run on the basis of a whim and a caprice. Whatever one person wakes up and thinks about in the morning and writes down then becomes the law, and everybody must abide by it. And as I can say, and as I can confirm, this is not what this Constitution of Zimbabwe anticipated, particularly as it says, this Constitution is the supreme law of Zimbabwe, and any law, practice, or custom conduct inconsistent with it is invalid to the extent of its inconsistency. So, this then brings us again to philosophical questions such as whether it is possible for a sitting government to commit an act of treason. I think it's uncharted waters, but it is possible, especially where there is a supreme constitution. Remember, there was a time when Zimbabwe was run on the basis of a parliamentary system, or rather parliamentary supremacy or parliamentary sovereignty, as happens in the UK, where whatever was written in the constitution was taken to be the law. This one purports to be a constitutional democracy, where the constitution then is the guide and the basis for legal authority and constitutional governance authority. So, against then the backdrop of the fact that Section 3, subsection 1b says Zimbabwe is founded on the principle of the rule of law, and Section 3, subsection 2, B, which talks about an electoral system based on free, fair, and regular elections, And on the basis of section 32F, which says Zimbabwe upholds the respect for the people of Zimbabwe from whom the authority to govern is derived. We then go and check section 328. It says it's amendment of the constitution. So it's all about how ZANU PF will amend the constitution, whether they have the rights, the necessary thresholds and minimum quotas within the parliament and senate to do this or not. It says in this section, constitutional bill means a bill that seeks to amend the constitution. So several bills will have to be run, or it would be one bill that would then seek to amend all those different provisions that I spoke about. And then term limit provision means a provision of this constitution which limits the length of time that a person may hold or occupy public office. You see, there is reference in the same sentences here to a person and a public office. So the office of the presidency runs from 2023 to 2028. That's the office of the presidency. It does not matter who is occupying it. That is a term of office of the presidency. And in section 328, it's not about the office, it's not the public office that we are talking about when you talk about the term limit provision, but it is the person. So a person in this case would be Mr. Mnangagwa. Now, in ZANU PF's reasoning and logic, they have been conflating and confusing the duration that a person can hold office, or rather the term limit provision requiring a person to hold office, and the term of office itself. So they need to debunk this issue, because as long as they are confusing and conflating Mr. Mnangagwa's in a capacity to hold office in a personal capacity and the presidential term of office, then surely something is not adding up. Remember when Mr. Mugabe was deposed or taken out of office, whatever, in 2017, his term as a person, he ceased to be president in November 2017. But the term from 2013 to 2018 did not end. Mr. Mnangagwa came in to complete it for several months before the 2018 election. So, the term limit provision, therefore, is addressing Mr. Mnangagwa in a personal capacity. And that is what section 91(2) is referring to. Whilst still looking at section 328, let's look again at section 91, subsection 2. It says a person is disqualified from election as a president if he or she has already held office as president under this constitution for 2 terms, whether continuous or not. And for the purpose of this subsection. Now, so this subsection 912 is talking about a person who is disqualified. And section 28, subsection 1 says, a term limit provision means a provision which limits the length of time that a person. So, section 91, subsection 2, and section 328(1) are referring to Mr. Mnangagwa as a person. And they are referring to all those members of parliament as persons. So it is their terms of office that are in focus. And well, so reference to a term limit provision is significant. That distinction is very, very significant, because that's where the confusion seems to be, where some people think that this is referring to a parliament, whether it can run from 2023 up to 2030. so that if they amend Mr. Mnangagwa's eligibility, then it automatically grants the parliament a 2 extra year period. As I said, I don't see in this constitution where they are deriving that kind of reasoning from, because surely it defies all logic. It says, I wanted us to look at subsection 1 on the term limit provision. For the purposes of this discussion, I will not dwell much on the other sub-provisions of section 328. Assuming that they run the bill through the several readings and it gets to a point where it is accepted, in fact, it gets the necessary votes, 2/3 in National Assembly and 2/3 at the Senate. Subsection 6 is what I want us to pay attention to. It says where a constitutional bill seeks to amend any provision of Chapter 4 and Chapter 16 within 3 months after it has been passed by the National Assembly, in the Senate, in accordance with subsection 5, it must be submitted to a national referendum. So that's one area where there's been a discussion and mixed views. Some saying that the proposed amendments by ZANU PF will go through a referendum. Well, my reading of section 328 subsection 6 does not seem to confirm the reasoning that these amendments, proposed amendments, will have to go through a referendum, because they do not affect Chapter 2, which is the Bill of Rights. And because they don't affect the Bill of Rights, therefore, they are not there's not going to be a requirement for such for these provisions or these amendments to go through a referendum. So it's only Chapter 4 amendments and Chapter 16 amendments which must go through a referendum. As I've said, Chapter 4 is the Declaration of Rights, which is some people call the Bill of Rights. And then Chapter 16 is on the agricultural land and any rights in respect of agricultural land and so on. So, from my own reading, there is not going to be a requirement for a referendum. On that point, ZANU PF may have got it right, that they do not require a referendum to get these bills to pass through. And then, so as I have said, Chapter 4 and Chapter 16 don't require amendments of Chapter 4 and Chapter 16 of the Constitution. Do not require a referendum. But I want us to look at subsection 7 because that's the most interesting part for me, and I'm going to end with this one. Notwithstanding any other provision of this section, an amendment to a term limit, now we know a term limit refers to a person. It does not refer to the duration of the life of a parliament or the life of the, the term of office of the presidency. So it says here, the effect of which, any provision, the effect of which is to extend the length of time that a person, I want you to underline the word person, because this is referring to a person. It's not referring to the term of office. So that's why I keep wondering, why do people in ZANU PF assume that if they can get this disqualification in section 9(1) subsection 2 lifted regarding Mr. Mnangagwa, then it automatically confers upon him an extra mandate? Where do they get that from? Because it says, notwithstanding any other provision, an amendment to a term limit provision, the effect of which is to extend the length of time that a person may hold or occupy any public office. So it's the term provision that a person may occupy a public office. So the term of the public office itself is is actually determined by section 143.1, and so we say they will have to amend that one as well. And then it says this any other provision does not apply in relation to any person who held or occupied that office or an equivalent office at any time before the amendment. So, as I said, ZANU PF will also have to amend the amending. They will have to amend the amending provision, because so really they will have to begin by amending section 328, subsection 7, because it says even if they manage to amend all these other provisions, if they do not amend section 328 subsection 7, this will not apply to Mr. Mnangagwa. It will not apply to the current legislators, because they have already held office. So the principle of legality, which says that the law does not operate retrospectively, means that the new amendment will not be for the benefit of the incumbent. It will not be for the benefit of those who are holding office now. And to cap it all, according to the principle of legality that I've been mentioning so many times, and according to rules of statutory interpretation, common law rules, as the Roman Dutch rules that are law in Zimbabwe after all, as well as the rules of English law, which also does hold sway in respect of the jurisdiction of Zimbabwe, and even common sense. The law does not operate with retrospective effect, because you can't pass a law today and expect people to have observed it yesterday. It is absurd, it is illogical, it is unfair, it is unjust. So any amendment on the strength of section 328 subsection 7, it says that the provision does not apply in relation to any person who held or occupied that office or an equivalent office at any time before the amendment. Now, this is very straightforward. If, suppose they have all the necessary numbers and technical issues, technical expertise to bring about these amendments, the principle of legality does not enable them or allow them to enjoy the fruits of the amendment. Why is that the case? Because when the people voted in 2023, it was on the basis of the law of the time, which empowered the electorate to confer a 5-year mandate. So that mandate was conferred by the electorate, and now the electorate is functus officio. It has ceased to be relevant in respect of this particular term of office. The function and the mandate of the electorate resumes at the end of the 5-year period. That is precisely when they can then grant another term of office. So an attempt to extend the 5-year period to a 7-year period means that it cannot automatically kick in and come into effect in 2028. But it simply means the parliament will have to dissolve, the president will have to call for an election, the people must then vote and confer the parliament a 7-year term and confer the president a 2-year term or whatever. But the president and the parliament may not assign themselves a mandate that the people of Zimbabwe did not give. in 2023. If they go ahead and do that, that would be in violation of the Constitution, that would be in violation of the principle of legality, that would be a subversion of the Constitution, because it would then imply that as soon as the President and the Parliament and all these other different legislatures at different tiers of government level, the moment they were sworn in, they colluded among themselves to amend the Constitution, to subvert the will of the people, and to give themselves a mandate contrary to the wishes of the people of Zimbabwe. Right. I rest it on that point. I know I have touched so many controversial issues that people have probably not thought about before. But I'd like to engage more on this. Thank you very much for taking your time to be part. Remember to look for my other videos, to follow me on my channels. May God bless you. Bye-bye.